Need a search engine optimization SEO services? Then get in touch with our professional and friendly team to learn more about our range of custom and tailored services designed to suit your exact needs. Every one of our professionals have acquired years of experience, which ensures you get the very best. Our experienced staff is waiting to hear from you and to answer any specific questions that you may have on how we can meet your needs. Just ask for a consultation and let us prove our commitment to you as we promise to maintain the highest level of quality and commitment. Your satisfaction is our prime concern. So please, don't hesitate to get in contact with us and let us show you all the great options we have.
And we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media, broadcasting live on the Worldwide Coalition Network here at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty Twitter at Coalition_radio, and of course the mothership, both at coalitionradio.us and coalitionradionetwork.com. It was in November of 1996, the University of Florida Gators were on their way to yet another NCAA national championship. But as they say, the real heavy hitting took place in the U.S. Court of Appeals, appealing a case, if you will, hearing a case originally decided on by the First Circuit Court, where a decision of the United States District Court, if you will, brought us to something called Title IX, as we know it, and in doing so, redefined the relationship between universities, student athletes, the NCAA, and the industry that we know as college sports. Rejoining us, I should say, but for the first time since we're in our new facility here up in the hills above La Prave, is attorney Lynette Labinger. She is I would call it a corresponding attorney for the Rhode Island chapter of the American Civil Liberties Union. She is a graduate, if you will, of Mount Holyoke and the New York University School of Law. Attorney Labinger, welcome back to the Coalition. We're thrilled to have you here.
Thank you.
And maybe if you could just explain, just so, you know, for those who obsess over these things, what is your relationship now with the ACLU? In the past, when we've spoken, you had a full-blown private practice and partnership. What's your work relationship now?
Well, my former law firm of 35 years closed in 2018 when my partner retired, and I am in private practice, but I've decided to limit my practice to cases that the ACLU of Rhode Island sponsors. So excellent. I'm still in private practice, but I'm only doing their cases. Excellent.
And as I've seen come across the wire, there have, let's just say the case matters which the ACLU deal with range from, in situations like this, to groundbreaking redefinitions of if you will, gender priorities within one of the biggest, possibly most out-of-control industries in America, and that's college sports, down to the mundane where seemingly town councils routinely out of control, we call it town councils got mad, seek to impose their own laws, federal, state, and local, for things like how many people they'll let live in a beach house, and you know what constitutes the medical cannabis law here in this state. So it is a diverse, target-rich opportunity, I would imagine, for an attorney like yourself with your experience here in La Prave, or Little Rhodey, as we call it, isn't it? Does at times it beg disbelief?
No, I pretty much assume that these are the kinds of issues that are going to keep cropping up. It's always pleasant when they finally go away, and there's always a new challenge.
Well, something that has become, I would imagine, one of your life's great efforts as an attorney and as an individual as well has got to be Title IX. In the time that we have, I'd like to just, in a sense, for lack of a better term, do an infomercial on Title IX, where it came from, where it stood, or where we thought it all stood, and now all of a sudden we find ourselves during the height of a national crisis, we find ourselves, if you will, my words, not yours, in the reindeer games that seems to take place anytime you mix in universities, college sports, the NCAA, and the whole crew. So let's talk about Title IX. It's a term that everyone's heard. They equate it with collegiate sports at this point. But what is the origin, and what is the federal code, and where did that come from? What was the origin of Title IX?
Title IX is a spending statute. The federal government passed it originally in 1972. It's technically called the Education Amendments of 1972. I can give you the site, but in any event, it basically says that any educational institution, which means colleges, universities, school districts, school departments, anyone that receives federal funding is prohibited from discriminating on the basis of gender.
Mm-hmm.
Now, when it passed in 1972, it was originally adopted because schools discriminated historically in their admissions for graduate school. So medical schools didn't accept the same number of women as men, law schools, various professional schools, and that was the target, to stop discrimination and quotas against women at the graduate school level. There were certain exceptions for same-sex schools at the college level and lower, but at the graduate level, no more discrimination on the basis of gender, which was historically the case. Mm-hmm. That's where it started in 72, and almost immediately, the institutions realized that it also would apply to college athletics, right, where historically they were limited to men, or the lion's share of the support was for men.
So even though, for example, the fulcrum of this was Brown University, even though Brown University is a private corporation, their decision, their willingness to accept federal monies, in a sense, put them in line for federal supervision when it came to discriminatory practices. Is that a good synopsis?
That is correct. And originally, it created a whole movement in the 70s of schools to beef up or add women's sports. There's a lot of discussion as to what that meant. Mm-hmm. There were regulations adopted by what was then Health, Education, and Welfare. It's now administered by the Department of Education. And then the U.S. Supreme Court issued a decision on another area, not on athletics, but basically saying that the federal spending dollars only applied where they were received. And since there are no federal spending dollars that go to athletics, back in the 80s, that was the end of Title IX in athletics for about 4 years. Then Congress passed another law restoring the scope of Title IX to apply everywhere an institution it didn't matter where the dollar came in, it applied to everything. That was 1988. One of the things that's kind of interesting is that frequently the pressure to cut sports, and that includes women's sports, follows a financial downturn. So when Brown did it in 1991, there was a financial downturn, and they cut 4 sports, 2 men's sports, 2 women's sports. But at the time that they cut the sports, women didn't have the same opportunities that men did. So when they thought they were cutting them proportionately, they were already, women were already underrepresented. And that's when we first sued Brown in 92, and it went all the way up to the Supreme Court in 96.
Right. Now, explain to folks, because this seems to be one of the nuances, and for most of us, again, we deal with sort of the generalities as they're presented by the media. We don't get a real in-depth look. But what is the difference, if you will, between university-funded and donor-funded? Because wasn't that the crux, if you will, of the sort of the final straw from a layman's perspective, and reinterpreting the support for, I guess it was women's gymnastics and volleyball?
Well, I mean, Brown University used a variety of terms to describe the teams that it supported fully, and the ones that it allowed to participate in varsity athletics if they found their own funding. But at the time that they cut gymnastics and volleyball in 91, they said in theory they could continue to compete if they found their own money. But historically, primarily because women's sports have a much shorter history in college and university athletics than men's, and have the donor base to raise the money. So that was part of the litigation. Brown quickly recognized that they could not set financial considerations as a justification to give women a lesser piece of the pie and a not an equitable program. So that went away. And we just litigated on the questions of whether they were providing an equal program and also providing equal participation opportunities for women that they did for men.
Now, when I ask you this question, don't shoot the messenger, but clearly the reporting on this issue over the years has focused extensively, and this is coming from me, extensively on the nature of the sports affected as opposed to the equity issues underlying. That's my contention. And I go back to Providence College, of course, when the Sturm und Drang that resulted from the elimination of Providence College's baseball team. I remember there was I think it was Lou Merlone from the Boston Red Sox, who was kind of the hometown hero because he was a PC guy, is often the obsession, not the underlying issue. So when I ask you this question, please understand you're speaking to a state filled with sports addicts, not so much folks who are interested in the nuances of some of these laws. Why is it important, all right, that there be equity in relationship to essentially college level sports? Why is that so critical?
Well, what they've found over the years is documenting a few things that are really important. One, first of all, most people don't go on to professional sports. Their college or university career is the epitome of their athletic undertaking. And that applies to women just as much as it does to men. To participate in the team building in an activity where they're supporting their colleagues and getting the training, the coaching, the experience, and for a lot of students at a lot of schools, getting in, because it's been well documented that there are admissions preferences in recruiting that benefit the individual who might never have gotten into that school, whatever that school is. And that's as valuable for young women as it is for young men. And from my perspective, and I'll just say that when I started this case, I knew nothing about intercollegiate athletics. I had support from our supporting organizations. At that point, it was just Public Justice. Now it's Public Justice and the ACLU of Rhode Island. So I had to learn a lot about it. But these are really valuable and important opportunities that women now get in such a much larger measure than they used to in the past. What our approach has always been is not that we're trying to build a bigger table so that everybody has a seat, and not eliminate seats and reorganize a small table and kick people off the table like musical chairs, but rather have more. And one of the things that I always have felt good about in terms of our litigation is that when we got the courts to order Brown to put the 2 women's teams back, Brown put all 4 teams back. And over the years until right now, it hadn't cut any teams. That's over 20 more years later. They added more women's teams over the years. It's unfortunate that they've decided to cut teams now. That's why we're back in court. But if you look nationally, there's been it's not a zero-sum game where the advantages that women have achieved nationally mean that men have lost them. In fact, it's just the opposite. There's been net increases for both men and women in athletics nationally because of the pressure of Title IX and the need to comply with Title IX. And then the consumer, which is the students and their parents who are seeing this school has a better athletic program than that one. And even if they're not actually on the teams, that's part of the college experience. So they want to go there.
Right.
And it's created a kind of like a athletics arms race, which is a good thing.
It's interesting. I found in my attempt to get a better understanding of this, the World Economic Forum published in conjunction with the Women's Sports Foundation, under the guise of Donna DeVerona, of course, who became a household name years back in terms of her skills in sports. And one of the more telling nuances of this is when they did surveys, the top 3 leadership skills developed by sport, motivational skills, the ability to see projects through completion, and team building. And they found that 74% of respondents say a background in sports accelerated a woman's career. As the father of 2 daughters to that, I say, huzzah! It's
Exactly.
we're affording the same type of competitive advantages in skill sets across the board with at least a level of equality. And to that notion, I will tell you, in my household, its effects have been prominent. So we flash forward now. Throughout this 20 years, folks need to understand that there's an annual reporting component, isn't there?
Yes. In 1998, we came to an agreement as to how we were going to measure Brown's compliance, and we review it every year. And there were some years where they didn't quite make their compliance, but it was through some issues with the size of the teams that were anticipated that didn't happen. But up until just now, they never tried to cut opportunities for women.
Right. And the degree with which universities have, and folks need to understand that this is not a Brown University paradigm. This affects every college, every university that accepts federal funding. So this has had a staggering impact on virtually every athletic program in the country, correct?
All colleges and universities. It also theoretically applies to high schools, not quite to the same degree in practice or practical circumstances, but yes, any educational institution that receives any federal funds is covered by it if they have an athletic program.
Excellent. The formula seems to be relatively complex. Can you just give us a little insight into how that was determined? Because what's unique here is that your involvement has spanned really the life of this, hasn't it? You've seen this from the beginning, and because, my next question is going to be a little bit of, you got to go with the emotional question at least once. Number one, the complexity of the formula involved, but number two, I've got to also ask you, after all this time and all this effort and the level of compliance and the notion that as a nation we've really made this approach our own, how does it feel to all of a sudden find this sort of naked, aggressive noncompliance?
Well, there's a couple things. There's 3 ways to measure compliance under the federal regulations. Mm-hmm. The one that Brown chose, because Brown was able to pick its own remedy, was the one that is probably the most complicated, which is a requirement that the number of athletic opportunities for women, because they're the underrepresented gender in Brown's program, be substantially proportionate to undergraduate enrollment. Now, since undergraduate enrollment changes slightly from year to year, that can become a moving target. But Brown chose not to do was to fully and effectively accommodate the interests and abilities that were there. That's the classic bigger table. You build a table big enough for everybody who wants to play, and it doesn't really matter how many men are out there, how many women are out there, as long as you're giving the women their share of what they want to play, you could have a bigger men's program. That's apparently how most schools are trying to, measure their performance. But, a lot of colleges have recently have substantially more women undergrads than men. So we're talking like 58, 62%, whereas Brown hovers around 53%. So it's an even bigger challenge for them to have their programs stay with substantial proportionality if that's the version of the compliance that they want to do. But that's what Brown wanted to do. And our position was initially, and the way we came about it was that we agreed with Brown that they could do it that way. And as long as they were within 3.5% of undergraduate enrollment, that was okay with us because they made a commitment to put all of the teams back. That women's gymnastics, volleyball had already been reinstated. Women's fencing was new, women's skiing was new, they added equestrian. So as long as they had this big table, we were okay with 3.5%, which is a very large percentage when you're talking about a program that's almost 900 people. You can put a few teams in that difference. But we also stipulated that if they ever cut any women's teams or elevated men's teams without, coming back to us and doing something else for women, then that percentage would drop down to 2.25%. And so all these years, we've just gone along checking out the numbers. It's really not that complicated when everybody is trying to stay in the same place. But just recently, Brown decided that it was cutting teams. It had a long explanation of what it was doing. It recognized that it needed, if it was going to cut teams, to get down to 2.25%. And it originally announced it was cutting 5 women's teams and 6 men's teams, the 6 men's teams including men's track and field and cross country, which is a very large program, relatively speaking. And there was a big groundswell of opposition to the cuts. The track program did a masterful job of public relations. And initially, the Brown president said that she was sticking with her decision because if she didn't cut men's track, field, and cross country, Brown would not be in compliance with the settlement if they made no other changes. And then 3 days later, announced that they were doing just that, at which point we notified them that that was a violation because now they were cutting the opportunities in the teams of twice as many women as men and not going to be in compliance. Brown's response is that they will be in compliance because they're adding a sailing program. And our position is that it doesn't exist yet, so you cannot substitute promises for participation. And that's why we're in court.
There's 2 backdrops I'd love to observe. First off, when you go back to the original litigation, going back into the mid to slightly late-ish 90s, first of all, it's an astonishing degree of legal talents that ultimately became involved in this. And, and buried, by the way, in the Brown website is something under the Brown University News Bureau. A gentleman named Mr. Nickel, who is the director, is the entire history of the case in old school, 10-point font. But I mean, folks like Deval Patrick represented the Department of Justice. Julius Michelson, who for many was one of the great attorney generals in recent history here in the state of Rhode Island. He was involved in the case. Folks like yourself. It was really sort of a case for the times. And while people like to point to a certain socialite case in Newport, I would argue to you that given the people, the range of academic institutions from across literally the country, big and small, that this was, if you will, a case for the ages here in Rhode Island. The second thing I'd like to reflect on is, and this is simplistic. I mean, I'm sure you've seen it as a longtime resident of Providence, Rhode Island, in the greater La Prave area, is that there's always this sort of animosity, if you will, sort of a mixed love-hate with Brown, if you're one of the regular folks. I have to just look at the raw numbers. And when you see the incredible size of Brown's finances, true, they're not Harvard, they're not Princeton, but they're right up there. They are themselves probably a Fortune 100 company if they were to be measured as that. The amount of money that we have to be talking about relative to the size of their endowment begs a question that an agreement put in place by Vartan Gregorian, who, again, is one of the great recent presidents, if you will, leaders of Brown University, yes, the school in Fox Point is named after him. Why would that, President Paxton, why would they, for lack of a better term, screw with this? It seemed to be working really well.
Yeah, I don't know the answer to that. I can tell you that back in the 90s, when we first came forward, Brown was trying to save about $80,000 a year on this program. It was very, very inexpensive. And we urged them to just put the teams back and we would declare victory and go home. And Brown absolutely refused and litigated this all the way to the Supreme Court. They paid us a lot of money in attorney's fees. They paid their own lawyers a lot of money in attorney's fees. And then they wound up building a better program, a much more expensive program than they had, and the economics were never there. I don't know what the rationale is now. They claim it has nothing to do with money. They want to be more competitive, but some of the women's teams, or all of them that they are cutting, are actually quite competitive. So a lot of what goes on, it seems to me, is Brown is not unique to have favored, high profile sports. A lot of schools have that. And my view has always been to try to hide behind football and say, you have to do it to football before you go after the women's teams, because that seems to be where the focus is. And, it doesn't really matter how good or bad scoring they have. Brown is always going to be committed to football. And that was the case back in '92 when we demonstrated that they had replaced the entire coaching staff for like $250,000. At the same time, they were pleading poverty, that they couldn't keep gymnastics and volleyball, at about $60,000 a year. So these are decisions, I'm not going to call them above my pay grade, but outside of my pay range. So I've never understood it. And I certainly would wish that Brown would look at it now and say, instead of getting involved in all this expensive litigation, maybe they would be better served to sit down at the table with us over how to get this on track and spend the money on the athletes and the rest of the students.
All of this, again, yet another backdrop. Brown is essentially rebuilding the East Side, or trying to win wherever they can. And from a layman's perspective, one would think that Brown, institutions like Brown, or large corporations, because Brown is a corporation, it just has got a fuzzier, warmer front end, lots of ivy, and people in crew shirts, roaming the East Side badly. But you would think that they would always avoid a structure being put in place to monitor their behavior. That seems to be the anathema to any large financial, educational, intellectual institution, isn't it? I mean, they've got this lifelong collar on now simply because they can't seem to do the right thing on their own. As someone who has got a wealth of experience litigating, why would someone put themselves in a position in that?
Well, I mean, we don't think of it that way, but I will say that regardless of our settlement agreement, none of these institutions operates in a vacuum. They all have a variety of spending limitations because of the federal statutes like Title IX. They're bound by state and federal laws that prohibit discrimination in all sorts of ways. I mean, I'll just give you an example. Brown builds a building, they have to comply, they have to make it ADA compliant. Now, that's kind of baked into the cake now. Everybody thinks curb cuts and accessible, handicap accessible or whatever else. But when those laws first got on the books, they were requiring people to change the way they design stuff. And they do every day. You cannot build a parking lot without making sure that it's ADA compliant. So I really think that it is a myth. If anyone thinks that they are, free to just do everything on their own, but in large parts, within those kind of like broad restrictions, they build their own curriculum, they decide how they're delivering their education, and they decide what kind of an athletic program they want. And the limitations that arise because of our lawsuit are not really, and at this point, they're not focused on the quality of the program or how competitive it is, but just that whatever program they're delivering to their men, they have to deliver one that's equivalent in terms of available opportunities to their women.
The point has been made that when you go back to all the litigation and what was birthed in the 90s was and let's see if I get this right, was a settlement not settled. And that seems to be a very important distinction. Can you elaborate on that?
No, I think we achieved a settlement. The fact is that we have been in the same settlement for some 22 years before this issue. Been able to work everything out. Mm-hmm. It's not that Brown has every year managed to maintain the percentage that was required, but when they slipped, we all identified it, and they gave us their plans as to how they were going to correct it, and they did. So it's been a very long run. I'm certainly disappointed that Brown chose to take the approach that it did now and didn't consult with us to try to figure out how best to deal with the issues that are presented. But I don't see it as something that was, doomed from the outset. I think it worked pretty well up until now. Okay.
So now looking at your current litigation, which from a legal standpoint, I believe, and again, correct me if I'm wrong, is essentially just another filing of the original litigation. And maybe I'm oversimplifying that, because there's still Amy Cohen et al. Plaintiffs versus, and this is kind of a fascinating note if you're a Rhode Island file, if you will, if you love Rhode Island history, versus Brown University, Christina Paxton as successor to Vartan Gregorian, and Jack Hayes as successor to David Roach, defendant. Again, continuing this long history, what are the next steps? You file for relief, what's called expedited relief requested. Are you looking for a restraining order on the elimination of these sports? What specifically do you hope to see come from this?
Yes, we are. It's the same case. We're asking for the court to enforce the agreement. We're asking that while the court is considering that it takes steps to prevent Brown from terminating these 5 women's teams, because what we know from our case and the other cases that have come up over the years under Title IX is that once you cut a sport, it's not like you can just snap your fingers and put it back. Right. The coach is gone, the schedule, they get written out of the schedule. They don't have recruits. They don't have conditioning. They don't have training. They don't have anything. And the sport quickly disintegrates. And then those athletes who want to play on that sport have no opportunities. So we've asked the court to order Brown to retain the 5 sports while the court's considering our motion. And we just filed it, I think, last Monday. Today's Monday, right? So a week ago. And we've had one conference with Judge McConnell, who has now got the case. And he's directed Brown to respond to our motion to expedite later this week. And also for Brown to give us certain documents. And then he's going to set a schedule.
You always have to remember in a situation like this, and I know you do, based on your literally your career-long commitment to this case. But for all the folks who are sports fans and are enraged about this or that, or the conventional media gets out there and does their typical superficial treatment, and here at the coalition we call it outrage porn, because you take the most superficial issue amongst a complex situation like this, and you blow that out of proportion for clicks or whatever constitutes media these days. But the heart of this, of course, are the students. So you've got a situation where students have committed to Brown University, and obviously it's one of the finest universities on the planet, but they committed to Brown University based on this, and it's interesting because allegedly there are no athletic scholarships at stake here, but based on this sort of quid pro quo that in exchange for athletic performance and participation and the ability to grow as an athlete, they'll, in a sense, be a part of a Brown University education. How disruptive is this to the students involved?
Well, it's heartbreaking for the students. The students, there are no athletic scholarships at Brown, which means that no one is in jeopardy of losing their financial aid because their team is cut. That's great. But so many of these athletes are very, very talented. They had their choice of a number of schools to go to. They chose Brown because of a whole bunch of things, including the athletic opportunities as well as the program. And now they don't have that. And it's really tough. And I can't tell you that it's tougher for the freshmen, sophomores, juniors, or seniors, because you can look at that in very different ways. The juniors and seniors pretty much a lot of choices in terms of transferring. They'd wind up having to sit out a year, and typically if they really wanted to transfer. A freshman's coming in, they just made a commitment to Brown just like a month before, and then all of a sudden their dreams are shattered because they picked Brown. They might have picked Brown over a number of other institutions and said, I'm committing to Brown, and now those other opportunities are gone. And now they're not even going to get to start their college career in athletics, let alone finish it at Brown. So every step of the way, it's really devastating for the students. And from what I understand, not being a varsity athlete by a long shot, it's, the club experience is a great experience for people who want the club experience, but it's very different. One of the things about the varsity athletes is their ability to manage their training, their competition, and their studies effectively, which Brown does. You've got a lot of scholar athletes at Brown. And that's the kind of thing, as you were talking about, that builds for a lifetime that you just don't get unless you have the actual varsity experience. And that's going away if we're unable to get some relief for these students.
And of course, my words, not yours, it goes without saying that if you allow one school to sort of, dip themselves over that line in the sand, if you were, of course, then you've got potential for chaos. I've got to believe every other university, particularly D1 or an Ivy League, and you've got leagues within the country, and I'll point out to the Patriot League, which is sort of a Division II non-athletic scholarship league, and you've got Division I schools, and then you've got the Ivy Leagues. How closely do you think other athletic directors and or university presidents are watching this case?
I don't think that it has the same impact that it did back in the 90s, because in the 90s there was no law, and we were one of the cases that helped establish the law. That law has not changed. What we're doing here is talking about measuring within a very narrow, relatively narrow margin of what Brown can do under an agreement that Brown entered. For other schools because there are other cases going on even now, they're much further apart in terms of their programs, and they do get sued, and they do, in many cases, get required to put the teams back. Two of our colleagues on this case recently were successful in getting teams restored at Eastern Michigan. There's cases around the country. So I don't think that anyone is going to be able to draw from this case an open invitation to start cutting programs without complying with Title IX.
Interesting. So then, the question begs, I guess, and this is a rhetorical question. Why, why do it then? And from the reporting, it appears that a lot of people are as baffled, perhaps, as the keener observers are. Why now? Why at this moment? And again, universities obviously, here in town, the Rhode Island School of Design, which is an amazing school, but not nearly as well capitalized as Brown University. They're all facing these exogenous events called COVID-19, and they're all having to essentially reinvent themselves overnight for what is unknown. So I get these sort of exigent challenges, but again, it just strikes me as, have any other schools in the state sort of towed that line, danced that dance, or have other schools largely been completely compliant?
I really can't tell you who's been compliant or not. You mentioned Providence College many years ago cutting teams. I can't remember whether you or I did or not, but I mean, one would have to look at each school case by case. Most schools are not cutting sports. There are, handfuls of schools that do this across the country. Sometimes they do the math correctly and cut correctly, which is, to me, always a tragedy. But a lot of others don't, and they get sued. And Title IX enforcement in athletics is alive and well. And, and I think that it has meant, as I said before, a net increase for both men and women, and a real appreciation of the value of athletics for women as well as men. I mean, I get thanked a lot by people I don't know who say, my daughter, my granddaughter got into fill in the blank school because of her athletic ability. And that's something that you couldn't say many years ago. And it hasn't taken away from men. So, a real positive thing.
Absolutely. Well, so Counselor, the next step then is there's a hearing coming up. Judge, for all intents and purposes, Judge O'Connell recognizes the timeliness of the response, and I guess we just have to wait and see. Again,
Yes.
As we like to do on this show, I congratulate you on clearly, clearly just a constancy in your efforts to challenge the difficult and not be at all at any level, professionally or otherwise, intimidated by some, like your other like the other attorneys in the ACLU, at all by this constant barrage of challenges. And it would be interesting at some point someday to pull together just the cumulative impact of ACLU attorneys in a state like Rhode Island, where there's such a strong tradition of support, and where it seems to be part of the legal DNA in this town. Given Rhode Island's reputation as being something of a Potterville, and you have to be a fan of an older movie to get that analogy, to see this type of cumulative effort put around entire careers is astonishing. And again, as a father of two daughters myself, congratulations on your efforts, regardless of the outcome. I'm sure it will, based on the skills in place to maintain this relationship, I'm sure it will end well. But regardless, amazing work. And the state of Rhode Island and folks have a lot to be grateful to folks like you and the entire range of activities performed by Mr. Brown and the American Civil Liberties Union. So, and again, I appreciate you for joining us. It's a hectic life. It's crazy. It's busy. These cases, when we have attorneys like you on, are often chaotic, require a lot of time spent in preparation for these hearings. This is not TV. This is the real world. So I thank you so much for joining us, and I hope you will keep us apprised of the situation.
All right. Thank you very much. Appreciate it.
Attorney Lynette Labinger, she is an attorney, if you will, with a practice revolving around the support of the Rhode Island chapter of the American Civil Liberties Union. Thank her for joining us tonight in her pursuit, if you will, of constancy in the support of Title IX litigation that's been in place for over 20 years. And astonishingly enough, our local university, Brown University, has sought now to, let's just say, take that dance over the line. We are the Coalition, loud and proud, outrage porn-free, civilly disobedient media, broadcasting live on the Worldwide Coalition Radio Network here at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty Twitter at Coalition_radio, and of course the mothership again at coalitionradionetwork.com. We will replay this interview a handful of times during the week, so if you see it pop up on the Facebook and you're just catching this at the end, it could be easily replayed, and it is certainly understanding the importance of university life here in this state and what it means to our quality of life, what it means to our economy, and certainly what it means to, let's just say, the philosophy allegedly put into place by the founders of Rhode Island. This case bears watching. Thank you. Have a wonderful night.